An accessory after the fact is someone who knowingly helps a felon avoid discovery, arrest, trial, or punishment. To prove that the defendant is guilty, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that someone else committed this crime of homicide or open murder. The prosecution does not have to prove that the other person has been charged with or convicted of the murder charge, and just has to prove that the homicide was committed. Second, that the defendant helped the other person in an effort to avoid discovery, arrest, trial, or punishment. Third, that when the defendant gave help, she knew the other person had committed the homicide. Fourth, that the defendant intended to help the other person avoid discovery, arrest, trial, or punishment. Now, the defendant is also charged with larceny. The crime of larceny in a building, the prosecution has to prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that the property was taken in from a building, in this case, it's alleged that it was taken from Christopher Reagan's apartment. Fourth, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off of the premises. Fifth, that the property was worth something at the time it was taken. Sixth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. Now, the defendant is also charged with the felony offense of conspiracy to commit disinterment, mutilation, defacement, or carrying away of a human body. Anyone who knowingly agrees with someone else to commit disinterment, mutilation, defacement, or carrying away of a human body is guilty of conspiracy. To prove the defendant's guilt, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant and someone else knowingly agreed to commit disinterment, mutilation, defacement, or carrying away of a human body. Second, that the defendant specifically intended to commit or help commit that crime. Third, that this agreement took place or continued during the period from October 14th of 2014 until October 27th of 2014. Now let me define for you the crime of disinterment, mutilation, defacement, or carrying away of a human body. A person not being lawfully authorized to do so, who shall willfully dig up, disinter, remove, or convey away a human body or human remains thereof from the place where the body may be interred or deposited, or shall knowingly aid in such disinterment, removal, or conveying away, or who shall mutilate, deface, remove, or carry away a portion of the dead body of a person, whether in his charge for burial or otherwise, whenever the mutilation, defacement, removal, or carrying away is not necessary in any proper operation in embalming the body or for the purpose of post-mortem examination, and every person accessory thereto, either before or after the fact, shall be guilty of a felony. This section shall not be constructed to prohibit the digging up, disinterment, removal, or carrying away for scientific purposes of the remains of prehistoric persons by representatives of established scientific institutions or societies, having the consent in writing of the owner of the land from which the remains may be disinterred, removed, or carried away. And I think that latter part of the statute may be an issue in this case. Now, the defendant is also charged with the failure to notify authorities of a dead body. To establish the defendant's guilt on this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant discovered the body of an individual. Second, that the defendant knew or had reason to know that the individual was dead. Third, that the defendant failed to inform a law enforcement agency, a funeral home, or 911 operator of the discovery of the dead body, and that the defendant failed to inform the authorities about the dead body with the purpose of concealing the fact or cause of death. Now, the defendant is also charged with concealing facts or misleading the police, lying to a police officer during a violent crime investigation. The defendant is charged with the crime of concealing a material fact or making a false or misleading statement or providing false and misleading documents to a police officer in a criminal investigation. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Laura Frizzo was a police officer who was conducting an investigation of a criminal offense. Second, that the crime being investigated by Laura Frizzo was open murder or larceny in a building, conspiracy to commit dead bodies, disinterment, or mutilation, concealing the death of an individual, or accessory after the fact to open murder. Third, that Laura Frizzo informed the defendant that she was conducting a criminal investigation. Fourth, that the defendant concealed information relating to that investigation from the officer by some trick, scheme, or device, using the trick, scheme, or device intended to deceive others. Or provided false information regarding that investigation to the peace officer in a document or statement that the defendant knew was false and misleading. Fifth, that the defendant acted knowingly and willfully. That is, the defendant concealed the information, provided the false information voluntarily and intentionally with the intent to deceive and not because of a mistake or other innocent reason. Sixth, that the information allegedly concealed or the information falsely provided involved a material fact. A material fact is information that a reasonable person will use to decide whether to do or not do something. A fact is material if it has the capacity or natural tendency to influence the officer's decision as to how to proceed with an investigation. Now again, don't be too anxious here about memorizing all of these elements. You're going to be given a written copy of these instructions, and I'm going to give you another series of instructions at the end of the trial. And so you'll have it with you for reference. All right, so the prosecution presents her evidence with respect to these crimes. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence. does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call in witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of defense witnesses after the defendant rests his case. This is called the prosecutor's case rebuttal. Now, after all of the evidence has been presented, the prosecutor and defense lawyers will make their closing arguments. Like the opening statement, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You will be given a written copy of these instructions that I'm reading to you. You may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, again, I will provide you with a copy of my final instructions for your use during your deliberations. Now let me talk about your job and my responsibility as judge in this trial is to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies in this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who decide this case, the facts of the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job, no one else's. You must think about all of the evidence, all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Now, when it comes time for you to decide the case, you are also to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. When judging the credibility and the weight of evidence, keep in mind the following guidelines. It is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of the witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on gender or national origin of the witness. Therefore, there is no fixed set of rules for judging whether you believe a witness, but it may be of help to you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest on how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other relevant evidence in the case? Now, the questions of the lawyers, the questions they ask witnesses, those questions are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assumes or suggests that it is. I rarely do this, but if I did, I may ask a witness a question. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the case. Now, we've had a lengthy out-of-court, out-of-presence proceeding, and sometimes the lawyers and I will have to have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. I will try to keep them to a minimum. I'm not here to waste your time. Now, I have already told you this before our last recess. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room, and only when all of your fellow jurors are present. When the trial is over, you may, if you wish, discuss the case with anyone or no one. That is entirely up to you. Now, we've already taken 36s, and when I do, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not, and you would do that through the bailiff. You must not talk to the defendant, the lawyers, or the witnesses about anything, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury, and when the defendant, the lawyers, and I are all here. Now, I need to caution you about the publicity in this case. It has some public interest. During the trial, please do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side or the other. So to be fair to both sides, you must follow this instruction. Now, this instruction, next instruction, is quite lengthy, and it involves a prohibition of considering information from outside. The restriction about to describe are meant to ensure that the parties can. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside of the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspects of the case. But if a juror were to do this, it would harm the parties. The parties' attorneys would have no way of knowing that a juror has gotten outside information and would have no chance to object if that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, the information about the case from television, radio, the internet, and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from jury service. You must decide this case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspapers, television, radio, or internet. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computers, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group, under court supervision. You must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I just discharge you from jury service. Until I have discharged you from your jury service, you must not share any information about the case by any means, including cellular phones or social media. But if you discover that a juror has violated my instructions, please report that immediately to the bailiff. Now I'm going to distribute to each of you notebooks and pencils. You may take notes during this trial, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened. If you take notes, do not let anyone except the other jurors see them during your deliberations. And I would ask that you please turn your notebooks over to the bailiff during recesses. Now, your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. Now, I've mentioned this during the voir dire. There are 14 of you. 12 will hear and finally decide this case. And as I explained to you at the beginning of this trial, the two alternates, if there are two left, would be by lot, pulled out of the barrel. I don't know, nor do the attorneys or anyone else, who those two may be. We'll have to wait until the line draw is made to determine who is going to be excused. Now, possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. Now, these instructions must be taken as a whole. I may give you more instructions during the course of the trial, and as I said at the end of the trial, I will be giving you a comprehensive, detailed set of instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. Now, after all of the evidence has been presented, and the lawyers have given their arguments, as I said, I will give you a detailed set of instructions about the rules of law that apply in this case. Then you will go to the jury room to decide on your verdict. The verdict must be unanimous. That means every juror must agree on it, and it must reflect the individual decision of each juror. Now, it is important for you to keep an open mind and not make any decisions about the case until you go to the jury room to decide the case. All right, why don't we come back into session at 1:30. If you choose to eat in a retail establishment, please keep your slips, turn them over to the bailiff when you return, and we'll reimburse you for the cost of your meal. Remember who you can't talk to and what you can talk about. But as soon as you're done with your lunch, please return to the jury room so we can